Any mention? Any mention?
Lordship, I beg to mention item number 22, Lordship.
Huh?
Item number 22 of the main list, Lordship. Lordship, this is that matter which is pending in Bombay, Lordship. The hearing is still going on, Lordship. I'm praying for 2 weeks, Lordship.
Because I'm instructed the hearing is going on a day, my lord.
You said the order's
No,
already
this is
been
before the
passed.
division bench now. The matter is being heard on a my lord. It's being heard on a day-to-day basis. So we're expecting some sort of an order. If lordships may grant us some time, perhaps about 4 weeks.
Item 20.
22.
Lordship.
No, Allied Blenders.
Lordship.
Yes, as the council submit that the matter is still pending for the Bombay High Court and expect to conclude soon. Let us matter be adjourned for 6 weeks. Yes.
Lordship, highly obliged.
Lordship, I have similar prayer for item number 19, Lordship. Lordship, I'm praying if this matter can come up after a week, Lordship. Some difficulty, Lordship.
What's the matter about?
Lordship, this is regarding promotion, Lordship, in Nectar, Lordship.
Nectar?
Lordship.
No objection.
2 weeks is.
Highly obliged.
May I please, Lordship, I beg to mention item number 25, Lordship.
Number?
Item number 25, Lordship. Joint request, Lordship.
You have objection?
No, Your Lordship. No objection.
Yes. 2 weeks.
Much obliged, Lordship.
Follow.
Supplementary list item number 1.
Your Lordship, I apologize. I have to, Your Lordship, may I please to mention one item, Your Lordship. Item 27, Your Lordship. Your Lordship, Mr. Pathak could not come today, Your Lordship, due to some personal difficulty.
Yes.
No objection.
Your Lordship, if this matter can be posted on 23.
You take the adjournment and I'll give you a date. Yes. They will come after 2 weeks.
All right, Your Lordship.
Please, Your Lordship. Your Lordship, I beg to mention item number 24.
I thought mentioning is over. What is this? 24 on whose behalf?
24, Your Lordship, on behalf of respondent number 6 and 7.
Your Lordship, I received prior information, so no objections on the matter.
24,
Anything remains?
No,
It's for
24, my
hearing,
lord,
Lordship.
that is a matter where the only one executive member is signed.
We'll set it aside. We'll call it out.
That's the only
Your Lordship,
issue.
the connecting counsel is our station. Mr. P. Open, Your Lordship.
You are here. Doesn't matter.
Doesn't matter.
He is the leading counsel, Your Lordship.
Who leading counsel?
Mr. P. Open, Your Lordship. I can only pray for 2 weeks' time, Your Lordship.
2 weeks?
After 1 week, Your Lordship.
No, you telephone him. Tell the matters come up tomorrow. Okay?
Tomorrow,
Subcommittee
Your
list.
Lordship.
Tomorrow. Highly obliged.
Please oblige, Your Lordship.
Tomorrow on the subcommittee list. We'll, all these matters we'll dispose them of this.
Please, Lordship, I beg to mention item number 20.
I thought it was over. Now again. 20 already mentioned, no?
20, no, 24 is mentioned. 22 was mentioned, Lordship. I'm for the petitioner, Lordship. This is that electricity dispute matter, Lordship. Let me say. For private.
Do you have urgency?
Lordship, let it come after a week, Lordship. They are taking time, Lordship.
1 week. Yes.
Supplement item number 1.
May I please, Your Lordship? The order which was passed by this Honourable Court was not complied with, my Lord. The order is on page
24.
26, my Lord. The relevant portion.
20?
26.
Yes.
Para 4, my Lord. According to
Dated?
the order was dated, my Lord,
4th March. 3
4th
months
March.
over.
Yes, my Lord. So already over, my Lord. 3 months.
Yes, I heard Mr. SD issue.
Please, Your Lordship. Lordship, I've just received instructions, Lordship, regarding payment. May I?
Already complied.
Lordship.
No, my Lord. No, my Lord.
Just give him a copy also. You have any disputed amounts that won't be allowed? But
No, not disputed, but my Lord, I will take instruction.
27,500 already paid.
Well, I will take instruction, my
Matters
lord.
being moved by Mr. SD, Mr. H. Karwanlang, learned counsel,
Lordship.
who has added appearance also for the respondent, has produced a letter dated 6 June 2025, indicating that all outstanding amounts have since been paid. Mr. Day to take instructions this day after tomorrow.
Sir, can I have a copy?
Yes.
Yes, we'll give it to you.
Daily list, daily list item number 1.
Please, Your Lordship.
7 to 9, well, we have no file affidavit.
Why? 7 to what about 1 to 6? That's all, only 9 respondents. How much time? 2 weeks?
2 weeks time.
For admission hearing today. That's it, admitted.
Your Lordship. Your Lordship.
That's great. Yes?
This item number 15 to 18 is also connected with the item number 1.
Connected?
Your Lordship. Or similar matters, Your Lordship.
After it's been filed here? No, what about 15 to 18?
15, 16, 17, 18 on a new case, in which instruction is awaited.
Or similar.
Item number 1 will suffice for the suspension.
Okay. Anyway, Dr. N. Mozika, please wait out for the 2 weeks time to file affidavit. Sir, prayers allowed. Mr. Fong Sui.
Your Lordship.
Yes. Learned counsel for the petitioner has also submitted that WPC 155, 166, 78, 325 are connected to the incident matter. Ms. Arkoni submits that two affidavits have been filed in the said in the other petitions. The affidavit filed by the state in this is 474 will suffice. Yes, after 2 weeks.
Item number 2.
In these matters also, I'm also required to file affidavit.
Which one?
15 to 18.
Yes, sir.
2 weeks time. Well.
Yes, sir. 15 to 18 part. So on that one, the Arkoni submits that the affidavit filed in what's the matter? 474 will suffice. I know affidavit will be further forthcoming from the respondents, state respondents. Dr. Mozika, please allow 2 weeks time to find.
Your Lordship, item number 2 is also connected with item number 1.
Okay, number 2 also?
Your Lordship.
Yes, okay.
Much obliged, Lordship.
Item number 3.
Number 2, well, number 1 can be 1 or 2 will be. But you have this of parties, yes.
May it please, Lordship. Lordship, on the previous day, Lordship had allowed me to file the detailed report affidavit in.
What's the matter about?
This is electrocution matter, my lord.
Matter regarding?
This is electrocution matter.
Electrocution, oh, okay.
Yes.
Lordship, I
You already
request
paid ex gratia amount.
Yes, Lordship.
How much?
So on the last occasion, my lord, this is a legal aid matter, your lordship, and on the last occasion they have paid that affidavit to be filed by them. So several dates have been.
Affidavit.
Yes.
Detailed affidavit, Lordship.
So I just.
Lordship, I just required 2 weeks time, Lordship. I'm preparing the affidavit, Lordship. I just.
You receive complete instructions.
Lordship.
Mr. Karana prays that you will allow for the 1 week's time to file.
Lordship, 2 weeks time.
Positively by next date, no.
2 weeks time, Lordship. Please.
Why 2 weeks? You say you've received all instructions.
Lordship.
You can sit right now and draft it out and get it signed tomorrow. What's the problem? You asked Mr. Sholai to do that before when he was a government advocate.
Lordship.
Yes.
Item number 4.
Okay, 2 weeks.
Obliged.
Lordship, Lordship.
Yes.
My lord, we was directed to file an affidavit. We have served them a copy. It is on the process of filing, my lord.
Mr. SD submits the. What about 5 to 8?
I pay 2 weeks time.
No.
Because
How many times you
Mr.
pay?
SK Hassan is out of session.
Who?
SK Hassan. Mr. SK Hassan.
So what's it to do with filing of affidavit? Yes? 5 newly implemented. Okay. Now Mr. SD submits that the affidavit on behalf of respondents 1 to 4 hours a day. We file in the course of the day. Stop annex Mr. M. Marak. Phones allowed further 1 week's time to file affidavit.
Obliged.
And this also answer.
5.
File.
File, Your Lordship.
Yes, what do you want now?
Hearing, Your Lordship.
Suspension matter?
Yes, Lordship.
Ready with the matter?
Not today, Lordship.
Not today.
Yes, Lordship.
Yes, party submitted pleadings complete. Just for hearing after 1 week.
Lordship. Thank you, Lordship.
6.
Wait, please, Your Lordship. Your Lordships, I require 2 more weeks' time, Your Lordship, to file my rejoinder. This will be my 3rd time, Your Lordship, asking for time.
What's the matter about?
Your Lordship, this is illegal termination of service subsequent of a disciplinary proceeding, Your Lordship. Police matter, Your Lordship.
Rejoinder is absolutely necessary.
Your Lordship, I'm a little bit, Your Lordship.
Police matter.
Police matter, Your Lordship.
Last opportunity allowed. Last opportunity 1 week allowed to petition to file rejoinder.
Apply, Your Lord.
Yes, for hearing thereafter. Just for hearing immediately thereafter. Yes.
Apply, Your Lord.
7.
Well, for service on private respondent, my lord, we need some more time. We have written to the post office, my lord. We are awaiting their instruction.
Yes, the status of service on the respondent number 2 yet to be received. Response allowed further 2 weeks time to obtain status. List up 2 weeks for service reporting.
8.
May it please, Your Lordship.
Yes.
Your Lordship,
You file affidavit.
we will file it during the course of the day, Your Lordship. I'm for respondent number 5.
We just received the rejoinder from.
You filed rejoinder to
I filed my rejoinder to the
1 and 2
Lordship.
or 3 and 4.
3 and 4, Lordship.
Course of the day, Mr. V. Commissioner, Learned Counsel for respondent number 5 submits that the affidavit file in the course of the day. Mr. Mdongpur, Learned Counsel petitioner submitted that rejoinder to the affidavit filed by 3 and 4 since been filed. Just after
2 weeks.
say something.
2 weeks. 2 weeks.
2 weeks.
Lordship, the status quo order be continued.
2 weeks for affidavit. Yes. Status quo shall interim order.
Interim order.
Shall continue till next day.
Okay.
9.
May it please, Your Lordship.
Yes.
My Lord, in this case, I have filed a impleadment application. That is in this case number 88, my Lord, to implead the second wife of the deceased husband. The deceased husband of the petition. On the last occasion, my Lord, impleading the second wife, my Lord.
Or second. What? Yes, no objection.
No objection.
My Lord, that's the short, but then
very bad activity. Take down. There's an application for impleadment of one Simiti Pildaris Amora, PhD associated to be the second wife of the deceased employee, for which the petitioner is seeking grant of double benefits. Now, the same not objected to by the state respondents accordingly. So and so, as indicated in para 6 thereof, shall be impleaded as respondent number
2, Your Lordship.
Number 2. Number 2.
Yes, Lordship.
Number 2. Stop. This registry to make the necessary corrections. In this case, this goes off. In the main case, in view of the order passed in this case number 58, steps to be taken by the petitioner for service notice 1 the newly implemented respond up to within 3 days. Just up to 2 weeks for service report.
Item number 10.
I will wait, my lord.
May we please, Your Lordship, on behalf of 8, 9, 10, we have filed the affidavit in opposition.
8 to 10?
8 to 10.
8 to 10 or 8 to 19?
8 to 10, they have filed the affidavit. The
8 to
state
10 is you have
Ambush,
1 to
ambush.
7.
We have 1 to 7 and 11,
11.
Your Lordship. We have
8 to 10 is Mr.
Ambush.
Mahanta. 12? For 12? What's the matter about?
With regard to promotion, Your Lordship.
You receive affidavits?
Yes, Your Lordship.
Do not file rejoinder, not necessary.
We'll be filing rejoinder. Yes, Your Lordship. Your Lordship, the state is yet to file the
We're
affidavit.
not filing. On the last date, we have already
Yes,
stated.
Ms. Ibla submits that
Ambush is
will be allowed to file rejoinder to the affidavit filed by the respondents 8 to 10 represented by Mr. Edwin Monta with so and so, and for to the affidavit filed with respondent number 12, responded by Mr. Wanswet. Yes, M. Wanswet. Yes, this is matter after 2 weeks for rejoinder.
Joined by the petition.
Will you oblige, Your Lordship?
11.
Well, I'm praying for some time to file my affidavit.
Your Lordship, I object.
You object?
Your Lordship, the respondent number 1 to 3 had appeared on the 27/3/2025.
My friend will.
GHADC.
I supposed to file my objection, but only because my client is sick, he's not able to come with it. I think
What's the mistake?
Your Lordship, to state a notification, Your Lordship.
This notification to 10th April 25.
Yes, Your Lordship. 10 April
10 April
2025. 10 April.
No, this is, where's the miscase? I miscase. What's here? Miscase 89. Next.
Your Lordship, Miss Case 89.
Yes. You asked for instruction 27.5. Where's your objection?
I said I'll be filing it actually.
But tomorrow?
Because I said no, because that client actually is sick, my lord. Actually, I have to prepare. Now, just he is not able to come. He'll be coming, I think, within. Only give 1 week's time, I can find it. Because Monday or Tuesday, I think next week he'll be coming. It's a bit difficult because if I have make a submission that I'll be filing the objection.
Your Lordship, I had also filed a Miss Case number 23 of 2025, Lordship, for stay of order 7/3/2025 passed by the GHADC. The order is at Annexure 15, Your Lordship, page 169.
The verbal instruction that we have received, my lord, in this matter, if in case, my lord, they are allowed for plantations and all, June cultivation, my lord, there may be a law and order situation, my lord. And we have seen earlier also.
No, Your Lordship.
Not in this matter, my lord, in a particular matter where Mr. P.D. Sama was a petitioner, there was a law and order issue, my lord. And we have just said to maintain status quo, my lord.
Yeah, the order status quo.
Yes, my lord.
All jungle clearance, human related activities. And the second order, that is 10th May. 10 April, sorry.
10th April, my lord. There is status quo only, my lord.
So it's
Let it come next week, my lord. On the meantime, we'll file a small objection. Let it come next week, next
Your
Monday,
Lordship,
maybe.
this notification affects me, Your Lordship. I'm not allowed to cultivate.
What to do? We can't have all the facts on board. And suppose we pass some orders that has some other repercussions somewhere else. You file your objection.
Yes, Lordship, we put that next date. If we failed, we can.
After 1 week, we'll list it.
Lordship.
Yes, further time of 1 week granted to the response of file there.
Can it be 10 days? 10 days
No,
only,
Your
my lord.
Lordship, 1
Because
week.
from governance, my lord, they will send me.
Our instructions, yes. This also.
Item number 12.
Your Lordship, in this case, I have received Parvai's comment. I may be given 1 week time to file my counter, Your Lordship.
Where's the petitioner? None appears on behalf of the petitioner. Mr. Ibrahim, please phone allowed for the 1 week's time to file affidavits.
Hello, Blake Lordship.
13,
May it please Your Lordship. Your Lordship, we've received the affidavits filed by the respondent number 3 and number 7.
I filed today, Your Lordship.
Yes, Your Lordship. She will need a little bit of time to go through the same, Your Lordship.
What's the matter about?
Lordship, this matter pertains to the sale of the land, and which was purportedly sold to me. However, after the compensation amount came, it seems that
the same one. This is
the second round of
this is the second
litigation.
round.
Yes, Your Lordship.
Lordship, we have raised some maintainability of the petition. Lordship, may I elicit the
Let
matter
him
for
see.
admission hearing?
Let him examine.
I'll just have to go through the same, Your Lordship. They've just
What
filed in the
about
morning.
state?
Lordship, we have already filed.
Stop affidavits which has been
In this
filed
matter,
by
Your Lordship,
one number 7.
yes, Your
Matter for admission hearing after 2 weeks. Yes.
Lordship, in this matter, respondent number 5 has not yet made an appearance.
Who's 5?
5 is the person who had sold the land to me.
Notice not complete.
No, Your Lordship. Despite the fact that service has been affected on her.
5? You're applying for 5 also?
I'm for 7.
We've filed our service report to the effect, showing that service has been affected on the respondent number 5, Lordship.
You file affidavit?
Yes, Your Lordship.
Emma Tariang?
Emma Tariang.
Tariang or Baraya?
Tariang, Lordship.
Yes, affidavit has been filed today on behalf of the respondent number 7.
3 and 7.
However, though affidavit has been filed indicating service upon respondent number 5, no appearance is made on behalf of the respondent. Just after 2 weeks for admission hearing and for appearance of the respondent number 5 is.
How do you oblige?
14,
In this matter, my lord, respondent number 5 to 8 are yet to file their respond, my lord.
Lordship, I pray for some more time, Lordship. To file.
You already filed? For
Lordship, we filed for 1 to 4.
1 to 4 they have filed, my lord. 5 to 8 they have yet
For
to.
planning department, I require some more time to file my affidavit on behalf of the education department.
What's the matter about?
This is a matter, well, my lord, the petitioner was terminated because, my lord, he got 2 appointments at a particular point of time, my lord, but his brother has fraud, my lord. He has used his certificates to get an appointment.
Oh, yes, yes.
Yes, Lordship. He was holding dual posts.
He was not holding, my lord. But in the criminal case, my lord, he has been given clean sheet.
Yes, after it's been filed on behalf of Council 124, MCH Colonel prays for further time to file after on behalf of respondents number
5 to 8, Lordship.
5 to 8. Praise allowed this after 2 weeks. Yes.
Much obliged, Lordship.
hearing. Item 21.
Yes. Start. Ready? Yes.
We have come against the order passed by the District Judge Nongpo, page 116.
Page
116.
Yes.
I'll just read this order in entirety. This is the order dated 22/5/24.
Yes.
Para 1. The petitioner preferred the instant application under Order 39, Rule 2A, Code of Civil Procedure for breach of injunction order dated 8/3/2019 by the respondent. It is the case of the petitioner that the firm registered under the brand Mega has obtained a registration certificate under Section 23(2) of the Trademarks Act 99 in respect of all goods falling under Class 29 of the Trademark Rule 2002. The said firm is operating as Messrs. BR Industries throughout northeastern states of India and has been carrying on business in consumer goods throughout the country for decades. Sometime in the month of December 2017, it was discovered that the respondent was manufacturing, selling, marketing and distributing cashew nuts, processed food under the petitioner's registered trademark Mega without obtaining any permission, thereby has infringed the rights of the petitioner. The petitioner has approached this court by way of a title suit number so-and-so, praying inter alia for a decree of permanent injunction to restrain the respondent or their agents from infringing the trademark of the petitioner or from selling or offering for sale products of any description in pouch, pockets or cartons containing absolute and or deceptively and or confusingly similar to the petitioner's trademark. During the pendency of the said title suit, the petitioner filed an application under Order 39 Rule 9, read with Order 39 Rule 1 and Section 151 of the CPC for an ad interim injunction and for appointment of a local commissioner to visit the premises of the respondent. Thereafter, an advocate commissioner was appointed by this court who had seized the goods cashew nut from the premises of the respondent and has prepared a seizure memo dated 26/6/2018, white serial number so-and-so, for 1,400 tins of cashew nuts bearing the label Meghas Meghalaya were seized. However, the respondent submitted petition being petition number so-and-so for release of the said goods under serial number 6 of the seizure memo. Accordingly, this case number was disposed of by the order dated 8/3/2019, allowing the release of the said items under serial number 6 of the seizure list. However, this court has passed a restraining order against the respondent from selling products in pouch, packets, labels similar to the petitioner's registered trademark Mega in any packing having a similar and or deceptively similar to the petitioner's registered trademark Mega or any manner whatsoever till final disposal of the main suit number so-and-so. The petitioner preferred an appeal being MAF number so-and-so before the Honorable High Court of Meghalaya for violation of the restraining order dated so-and-so by the respondent. The Honorable High Court was pleased to dispose of the said MAF by the order dated 2/9/2019, allowing the petitioner to take appropriate remedies under the provisions of Order 39 Rule 2A CPC for breach of restraining order by the respondent. Hence, the instant missed case before this court. Learned counsel for the petitioner, Ms. Sri So-and-so, senior advocate, assisted by Sri So-and-so, advocate, submitted that the present case is of willful and deliberate disobedience of the respondent of the order dated 8/3/2019 passed by this court in Miss Case number 1 of 2018 arising out of so-and-so. The petitioner has procured several pouch packets of the respondent which primarily displayed the impugned trademark Mega and manufactured or packed in June 2019. These packets were produced well after the passing of the injunction order on 8/3/2019, along with the bills receipts explicitly established that the products were sold, marketed in pouch packets, etc. The said action of the respondent clearly demonstrates an absolute, willful, deliberate disobedience of the order dated 8/3/2019, which explicitly restrained the respondent from selling, marketing, or any other action involving the impugned trademark Mega. Learned senior counsel argued that the certificate of the CA, exhibit number so-and-so of the list of documents clearly reflects the sales turnover of the plaintiff petitioner, which may be relied on by this court for quantifying the cost penalty to be imposed on the defendant opposite party. Learned counsel and also prayed that strict action may be taken against the respondent for willful and deliberate disobedience and breach of injunction order dated 8/3/29 in terms of Order 39 Rule 2A of the CPC. Learned counsel for the respondent, Mr. A.A. Khan, submitted the respondent's company is carrying out business at Baniat without any blemish since the year 2005 and had other businesses in other states as well. The respondent's factory is being run by the manager and staff of the company. The respondent's company during the course of business adopted the trademark that is Meghas Meghalaya Cashew for trading of its product and applied for trademark registration on 9/8/2010 before the registrar of trademarks at Kolkata. After the examination and on due satisfaction, the same was published in Trademark Journal number 1649 on 14/7/2014, calling for objection. Having no objection from any corner, the Office of the Registrar of Trademarks issued registration certificate for the aforesaid trademark in class 31 on 13/2/25, having validity up to 9/8/2020. The said trademark was further renewed for a period of another 10 years with effect on 9/8/2020 by order white memo number so-and-so dated 26/6/20. The respondent's company garnered good appreciation for its registered brand Meghas Meghalaya, which is reflected from its turnover between 2012 to 2016. However, thereafter, in order to create direct association of its product with the company's name, Megha Cashew Private Limited, applied for registration of another trademark, namely Megha Cashew, for trading of its product under class 31 on 5/12/2016. The aforesaid application is under process before the Registrar of Trademarks at Kolkata, and the same has been published under Trademark Journal 1939 on 3/2/2020. The Learned Counsel submitted that the respondent herein, being the founding director, had directed the manager and staff of the company to stop marketing of its cashew nut products in the pouch of Mega Cashew as well as Mega's Meghalaya brand, but the products in tin under brand name Mega's Meghalaya was being sold. Though the cashew nut product was being sold in plain pouches of different sizes, the instruction was followed by the manager and staff. However, due to bona fide mistake on the part of the manager of the respondent's company, some cashew nuts was wrongly packed in the pouch of Mega's cashew during the period of June 2019. This fact came to the notice of the respondent only on receipt of notice from the Honorable High Court. Learned Counsel submitted that upon noticing few numbers of tins under the brand Mega's Meghalaya Cashew has been sold, the matter was inquired and it was found that the same has not been sold directly by the company but through some agents to whom the tins were handed over prior to court order restraining the sale of cashew nuts in tin packets under its brand. He also submitted that the respondent has the highest regard for the majesty of law and has not intentionally and willfully disobeyed the order of the court. However, the same has occurred due to mistake on the part of the manager and staff. Learned Counsel also tendered unconditional apology for the same and further undertakes that such lapses will not occur in the future. He also expressed that the respondent's company has established its factory at EPIP at Barnyard since the year 2005 by getting all requisite permission from government as well as the owner of one registered trademark, namely Mega's Meghalaya, which confers the right to use the same for sale of its cashew nut products, and another trademark, namely Mega Cashew, is under process for registration before the Registrar of Trademarks at Kolkata and has got good reputation of its product in market for its quality. Heard submissions at length, perused record and materials relied by the counsel for the parties. It appears from the contention of the respondent, the goods under the brand Mega's Meghalaya Cashew was being sold in the month of June 2019 after the restraining order from this court. Now this court will examine whether such breach was committed willfully and whether there was deliberate disobedience of the court's order. Order 39 Rule 2A is reproduced below. 2A, consequence of disobedience or breach of injunction. In the case of disobedience of any injunction granted or other order made under Rule 1 or Rule 2 or breach of any of the items of the terms on which the injunction was granted or the order made, the court granting the injunction or making the order or any court to which the suit or proceedings transferred may order the property of the person guilty of such disobedience or breach to be attached and may also order such person to be detained in civil prison for a term not exceeding 3 months unless in the meantime the court directs his release. No attachment made under this rule shall remain in force for more than 1 year, at the end of which, if the disobedience or breach continues, the property attached may be sold and out of the proceeds. The court may award such compensation as it thinks fit to the injured party and shall pay the balance, if any, to the party entitled thereto. In order to determine the breach of disobedience, whether it was willful or deliberate, the court will examine the conduct of the respondent right from the time of receiving notice of the suit from this court. The record shows that the respondent entered appearance in his defense and has also filed a written statement challenging the suit. The respondent, as defendant, had contended that the company had been granted permission to use a trademark under the name Mega's Meghalaya Cashew by the Registrar of Trademarks based in Kolkata. Therefore, the use of trademark containing aforesaid word Mega, along with addition, alteration or modification, use of the said word cannot be termed as violation of any registered trademark under the Act of 1999 and Rule 2002. Coming to the show cause filed by the respondent against the application under Order 39 Rule 2A, the respondent has clearly stated that their action was not willful or deliberate, but it was due to bona fide mistake. The manager and staff of the company had packed only few number of tins under the brand Mega's Cashew, which has not been sold directly by the company but through some agents to whom the tins were handed over prior to the court's order restraining the sale of cashew nuts in tin packed under its brand. To decide the issue of willful disobedience of this court's order, which similar manner amounts to civil contempt under the Contempt of Court Act. The guiding precedents in such cases was well settled by the Honorable Supreme Court in Food Corporation of India, Sukhdev Prasad so. The power exercised by a court under Order 39 Rule 2A of this court is punitive in nature, akin to the power to punish for contempt under the Contempt of Courts Act. The person who complains of disobedience or breach has to clearly make out beyond any doubt that there was any injunction or order directing the person against whom the application is made to do or desist from doing some specific thing or act and that there was disobedience or breach of such order. While considering the application under Order 39 Rule 2A, the court cannot construe an order in regard to which disobedience breach is alleged as creating an obligation to do something which is not mentioned in the order. On surmises, suspicions and interference, the power under 2A should be exercised with great caution and responsibility. The allegation that the respondent used the trademark Mega's Cashew was never disputed at any given point of time, and this trademark, though according to the respondent is pending for registration before the trademark officer at Kolkata, does not imply that they ever received the permission to use the same. The counsel for the respondent has tendered his apology before this court and submitted that upon noticing few numbers of tins under the brand Mega's Meghalaya Cashew has been sold, the matter was inquired and it was found the same has not been sold directly by the company, but through some agent to whom the tins were handed over prior to the court's order restraining the sale of cashew nut in tin packet under its brand. The petitioner in their petition has made specific allegation that the respondent's company are continuing to sell product in its pocket labeled as Mega, and on their inspection they found that it was manufactured in the month of June 2019. On careful perusal of the application filed by the petitioner, apart from the pleadings made therein, there is nothing to indicate or prove that the said pouch packets were manufactured in the month of June by the respondent. Well, this is the finding of the court, my lord. It says, my lord, I'll just read it once again. On careful perusal of the application filed by the petitioner, apart from the pleadings made therein, there is nothing to indicate or prove that the said pouch packets was manufactured in the month of June 2019 by the respondent. On the other hand, the respondent has clearly admitted that due to bona fide mistake, they wrongly packed the goods in the pouch packets during the month of June 2019. The burden to prove such willful disobedience of the court's order dated so and so lies with the petitioner, but in this case, although in the absence of material, the respondent has candidly admitted that such an act has been committed by them, and it is not known whether it was done intentionally or unintentionally. Also, during the hearing, the counsel for the respondent has tendered his apology before this court. Therefore, it is established that the respondent has flouted the order dated 8/3/2019, and it is the duty of the court not to allow perpetuation of wrongdoing and also to uphold the rule of law. The proceedings under Order 39 Rule 2A are meant to maintain dignity of the court in the eye of the public and to deter unscrupulous elements from flouting the courts of the court. The apology tendered by the respondent is hereby rejected for the reasons that if this court allows such apology, that it will virtually let the respondent go scot-free and they will achieve what they've set out to do. Even in the open court, the counsel for the respondent has repeated the apology, but this court does not find any reason whatsoever to accept the same. No litigant should get an impression that he can disregard the orders of the court with impunity and then get away by merely tendering apology. While upholding the majesty of law, this court directs the respondent to pay a fine of Rs 5 lakh as penalty for breach of the order dated 8/3/2019. The respondent shall deposit the amount before the court within a period of 2 weeks from this order, and the petitioner shall withdraw the amount from this court soon. So, in sum and substance,
do you agree with the quantum or with the order?
My lord, we are agreed with both, my lord. Our case is that the quantum is also on the much higher side, my lord. My lord, the learned trial court on one hand records that there is nothing, but the onus is on petitioner, my lord, to prove that there was in fact any violation of the injunction. Court renders a finding that there is nothing on record, simply taking the
statement of the manager,
apology tendered by the counsel, my lord.
No, he has made a very categorical statement that inadvertently some cashew nuts were packed in that pouch Mega Cashew, which is
but prior to passing of the court's order, my lord. And it was sold.
What stage is the suit?
It's fixed for cross-examination. What has happened, my lord, against the injunction order, they came before this honorable court. When we find that in the market, in violation of the injunction order, we produce the bills before this honorable court. Then this honorable court put it in a seal cover and send it back to the trial court. The High Court order is of 2/9/2019. After that, my lord, what has happened? My lord, your lordship has seen the order that has been made. There is an admission, clear-cut admission, that they have breached the order of the injunction. They have come that it is the mistake of the manager, the order was not known, and all those excuses will not do. Once there is you have breached the order, now it is only about the quantum of punishment, whether this 5 lakhs which was paid is on the excessive side, or your lordship will view it because this is an infringement of a trademark. And
No, that's why we want to know what stage is the suit.
Cross-examination.
It's been going on since 2019. The suit.
And there was a direction from the Honorable Court to dispose of it within a time frame. But that was because commercial courts, and now on the next day also, when we appear before the court in Nongpo, we have to file an application for transfer of this case to the District Judge Shillong, who is now the designated commercial court for the entire state of Meghalaya. So earlier there was no commercial court, that's why, and that court is now taking up the matter due to a specific direction from the division bench of this honorable court that the trial should be taken up by that court.
You see now infringement of the trademark.
Yes, my lord.
Your trademark, is it limited only to this aspect or earlier also?
Well,
now your dispute. Where's your suit? Where's your plaint? Where's the plaint?
Where is the plaint?
Today.
Page 27.
Yes. Page 26.
27.
Contempt of petition today.
26.
27. Type copy.
Where's the prayer? This is by
them, my lord. They file a suit against us. Page 35 is the prayer, my lord. A decree of permanent injunction restraining the defendants and agent so and so from infringing the trademark of the plaintiff and from selling or offer it for sale products of any description in pouch, packets or cartons containing absolute so and so.
Well, so far the violation
now
is
what is there left inside the suit then? Because if you have already candidly admitted that yes, you have not obtained your new registration for Meghalaya cashews, whatever, then this fact has been also established that you had inadvertently.
My lord, as far as plaint is concerned, my lord, whether I annex the.
So then this suit is, there's nothing to be tried in the suit.
There is in fact, my lord, because
in
fact there is a process under the Trademark Act. There is a sort of preliminary registration, my lord.
No.
We had obtained that prior to them.
Sir, it's wrong.
I'll just. But my lord, as it stands today, the petitioner company before your lordship has wound up, my lord. It's not in the business of cash or not anymore.
My lord, they may wound up. They may not, after the this order, they may not follow it. The concern is about the breach where then the injunction order was prevailing. Once you have said that that we are no longer disobeying the orders of the court,
so
from that
close this matter, you take that 1.5 lakhs. We'll reduce the quantum.
My lord, 1.5 lakh we have deposited before this honorable court, my lord.
You withdraw that.
My lord, I will not bargain with the court, my lord.
Well, but 5 lakhs is a bit excessive because it is, it's very shaky also. Whether this court has, that trial court given observation also that nothing concrete has been.
Turnover of more than crores, my lord, and they have by the counterfeiting the products, my lord, we have suffered enough.
That will go in your main suit.
Well, your lordship, I had not bargained with the money.
We are just here on a limited aspect of only violation of injunction. And we don't find any reason to interfere with the order. Only with the quantum.
Well, your lordship, in between, my lord. 50-50. Well, let it be 2.5, my lord. 50% he has succeeded here, 50% we are giving it away.
1.5 is more than enough.
The company is wound up.
Well, the company is wound up. It's not in the business anymore.
Yes. Order. Yes.
And your lordship will give a time frame to pay the money because
they already deposited to the Registrar General.
We'll be permitted to take that.
Yes, we'll pass orders.
Because with money, time, we don't bargain.
Yes.
We are obliged, your lordship.
Deeply.
23.
Meet please,
So Mr. Dubey finally made a physical appearance.
Yes. On last occasion also I made.
Oh, sorry, yes.
Prior to that.
I hope no Germans are being sought today.
No. Oh, sorry.
Samantha, pigeon bisa tayo bilay berkitab na. So bisa tayo bilay. Spend na YouTube. Yes.
Meet please, lordship.
All parties represented.
Yes.
You are now just Mr. Shulai is for?
I'm for the state, your lordship.
1, 2, 3.
3, your lordship.
Then 4, 5,
6, 7.
6, 7 you are there. And Reserve Bank?
Yes. I'm paying 8, 9.
Anxiously?
Yes.
Who's anxiously? Okay.
Who is proposed to be made the CEO now? That's private respondents.
Yes, please start.
Wait, please, Lordships. But the issue basically revolves around the powers the bank would exercise under the Cooperative Act, or the overriding effect of the circular. May I indicate to your Lordships, there have been two circulars issued by the RBI governing means since the respondent bank is a cooperative bank, certain kind of guidelines are also framed. Our projected case is this, your Lordships, that the petitioner, who is the CEO of the bank, is a employee of the bank under the regulation and service bylaws of the bank.
Yeah.
And therefore, he doesn't have any fixed tenure posting. Whereas in between, there is a guidelines of the RBI which says that for removal and appointment, prior consent has to be taken. In our case, that was done. Now, a circular comes in 2021 which tries to limit the tenure. And that circular has been put to challenge before various high courts. Ultimately, the matter went up before the Apex Court, and the Apex Court, has directed that the Honorable Madras High Court will decide that issue. And that is pending, and that has been stayed. That circular has not been given effect.
25/6.
Yes.
Actually, it's not 25/6.
Yes. And we have also come before your Lordships, There are two writ petitions. Earlier one, in which your Lordship was pleased to stay the effect of that circular, and that matter has been transferred to Madras High Court.
Transfer Madras High Court, why?
Because the judgment of the Apex Court,
Oh, all similar matters to go.
Yes.
So what impact does that have here on this present matter?
As on date, that circular has not been given effect to, and that is.
But, what effect will it have? Can this matter go forward?
Yes.
Then it's fine. Yes. We don't want in something later on that.
No.
From the side of the respondents, that is, it's connected. That we can't proceed. Is it connected?
It is.
Succeed,
then their cause of action will arise.
If they succeed in Chennai.
If they succeed, now it is under eclipse, because of the stay order passed by Lordship. Your Lordship, after staying the order, is transfer the matter to Madras High Court. Our case is, at this stage, this is premature. Because something under eclipse is one thing, and something quashed and set aside is one thing, So that has not been quashed and set aside till now.
Eclipse.
Severability, maybe comes. I'll have.
Severability, then you doctrine of severability.
Once in the eclipse, then that will come. I'll have a different view. If you're subject to what your Lordship says.
He is seeking a relief as if that circular of 21 is set aside. His cause of action will arise then, That is our case, It is at this stage only under eclipse, It has not been set aside in court.
By this order, you can continue.
My lord, this is what I am saying. Till that issue is decided, I should be allowed to continue.
You're continuing now, correct?
No, but they are not allowing me. That is the interim order we are sought for.
That's a physical thing in the bank. How will the court interfere here?
Because
on paper you're still continuing, correct?
That's true. But they are not allowing me to operate, my lord. I should, my lord, if your Lordship passes an order, that must have an effect, my lord.
Where's the early order? Let us see.
Yes, my lord. In my reply also I have an
Okay. So what's the stage of this case now?
Well, it's still pending. I have checked, my lord.
At what stage? Hearing?
Hearing. Because there are petitions from all across the country, my lord.
What on central issues? This
yes.
25/6
circular.
21.
Yes. In some of the cases, the virus of Section 35 provision has also been challenged on Banking Regulation Act. But my submission for your Lordship condition is this: My lord, there is a requirement of prior approval of the RBI for termination as well as for appointment. For me, appointment was given, prior approval was given, my lord.
Yes.
Even in spite of that circular, my lord, RBI has not given prior approval for my termination. They are seeking. So my termination has not been given effect to. And now in view of the suspension of that circular, which they themselves say that they are not implementing it because it is under challenge and they has not been implemented anywhere. So I have a right to continue, my lord. If the decision goes otherwise, my lord, then it would have an effect, my lord. Because had it been a case by virtue of that circular which in force and they would have accepted that termination of mine, my lord, then the case would have been different, my lord.
About the second aspect, madam.
And my lord, one more aspect, my lord.
Substantively,
Yes.
My lord, the respondent number 11, whom my lord they want to appoint, my lord, he does not fit in the eligibility criteria also, my lords. Very clear violations. And now my learner.
the second aspect, my lord, the main writ petition where these rules are pending before the Madras, can a consequential relief be granted by this honorable court, my lord? That's the second question, my lord.
That's what the court thinking also. Because that's why we asked the question that is it linked, it's
In all,
inextricably linked.
All across millets, there are stays and people who have been appointed under the cooperative acts millets, they are continuing.
No,
So
your
why
grievance is that though you're not been allowed to continue, that is your grievance.
Yes, there is no termination as such, because the termination will only be effected when RBI accepts it.
Let's see that.
Yes, Malad.
Where is the termination?
They have taken a decision in their board meeting, Malad, to terminate me.
Where is the termination?
Mal.
Board meeting.
Yes.
Resolution number is the meeting held on 19/7/23. No.
Malad will come to the communication also, Malad.
No page. Where's the page?
Just I am showing your lordship the minutes of the meeting, Malad. If your lordships come to page 135. 127, Malad. This is the minutes of the meeting held on 9/11, and the operative part is page 132.
Is this next year 21?
Yes, my lord.
Okay, 1 second.
They have formed a committee, NRC, which we have also challenged, my lord. The lordship find at page 132. The NRC gave the following suggestions, recommendation to the board. That the incumbent CEO was appointed by the board of directors in terms of guidelines contained in circular dated 31st December 29.
Where reading?
Blood page 132.
132.
It's part of the minutes, blood of annexure 11.
Yes.
Oh, sorry, annexure 21.
Okay, this is A.
Yes, A.
Yes.
That the incumbent 132. That the CEO was appointed. Yes, was appointed by the board of directors in terms of the guidelines contained in the circular so and so, and the same was accorded by the RBI on so and so. Based on the date of appointment, his tenure will be completed on 30th November 23 as per as RBI circular dated 25th of June 21.
Which is state now.
Yes. But once he is appointed thereafter, and there was no fixed tenure as such in, I'll also show that lordship.
Show the earlier circular by which there was no fixed tenure.
No, his appointment has no fixed tenure because.
Where did you get that from?
My lord will get the appointment letter, my lord. Page 54, my lord.
This is 18/2020.
Yes, my lord.
Okay.
You shall be required to, my lord, the first clause your lordship would see, you would be required to join our bank on or before 20th of November. Appointment of CEO in our bank is subject to approval from the Reserve Bank of India. Therefore, you will be appointed as CEO designate till such time you will receive the final approval from RBI. Now, your lordship comes last third line, lord.
Yes.
During your employment, you will be bound by the bylaws of the society, staff rules and general regulations of RBI. Now, this is very relevant because under the bylaws, I am an employee and my departmental proceedings, all my conduct will be governed by these bylaws. And there the retirement age is 60 years, lords, under the bylaws. Now, lordship would kindly come to page 56.
Now, where did you receive your approval?
My lord, that's I am giving, lord. Page 55, my lord.
This from Reserve Bank. Okay.
Yes.
The terms is that, is just this?
Yes. And lordship would see in next page, my lord, page 56.
What do you mean by 3?
Further, my lord, what has happened, generally one has to take prior approval. But here, my lord, subject to approval from the RBI, they have appointed me as CEO designated. Yes.
Okay.
And then, my lord, they passed this 17th March order, my lord. They appoint me as full-time Chief Executive Officer. And your lordship would see the bottom line, the other terms and conditions of your appointment will remain the same as per order dated earlier.
Yes.
So, all those conditions will come into play, my lord.
But Mr. Dubey, won't this your matter be better served if it goes on IA in the pending matter for Madras High Court? That this is a situation with this CEO who has been a lot.
Lord, had it been a case, my lord, where the RBI.
This is connected in the sense that if this circular of 2021
My
is
lord.
to apply,
My lord.
suppose it's in operation, not stayed, that means your tenure ended in 23. You would have no quarrel with that, since you are bound by the RBI guidelines and regulations, correct? Now this case has been stayed. So consequentially, you ask for consequential relief from a different court. Because it's linked to the main matter.
Lord,
How do we?
Lord, I would make my submissions like this. Lord, RBI is very categorical that we have not given approval for your termination. And your lordship has seen, just see page 50, the rules, guidelines. But there I am an employee, my lord. Because if your lordship sees page 57, the staff rules, the earlier post was secretary, which your lordship find at page 58. And under the revised rules at page 62, my lord, it is CEO. So these are the cadre of the officers we have. And I cannot be distinguished, my lords.
Yes. That category.
And my lord, page 64, rule 63. Every employee shall have a post in one of the cadres referred to in chapter 2, section 1. So the entire case is, my lord, that RBI have exceeded its jurisdiction when it has fixed the tenure. But there has been cases in which, my lord, people have been working as the secretary or the CEO of cooperative banks for more than 20-30 years, my lords, and now in the verge of retirement. And one limb of my argument is, my lord, this impugn order has been issued after the tenure of the corporate, my lord, the management has been over. Because, my lord, what they have they have usurped their jurisdiction upon themselves.
Now come to that termination removal.
Yes.
The minutes of the meeting.
(132), my lord. That was the, my lord, approval, my lord, the proposal, and the final decision your lordship finds.
Where is that?
at page 141. My lord knows, my lord remembers that November 9 meeting recommendation was made, and on 21/11, my lord, at page 141, in its meeting held on 21st November, this was approved. And my lord, this was communicated by next letter dated, my lord.
Where is that?
My lord, come to page 141.
Email.
No, report of the NRC, my lord, under clause G. The Deputy CEO read out the report of the NRC on its finding, observation and recommendation as guided with strict adherence to the RBI circular. The meeting discussed the matter at length, approved the recommendation of the NRC.
Where's the removal?
But this is the decision, and now they are writing to the RBI.
Where is it at RBI?
Next letter, my lord, 21st November 23. Clause 2, it starts, my lords. And my lord, RBI has said that you maintain the status quo.
No, in the earlier circular, that's what this, Mr. Rupi, in the earlier circular, so RBI does not tenure.
No tenure.
And now your other submission is that you'll be governed by the regulations of the bank itself.
Yes.
Where the post CEO is a cadre post.
Cadre post, yes, my lord.
Yes. So 2 and 3 is the effective resolution. The letter.
And my lord will kindly come to page 166, my lord.
Where's the reply to this letter?
My lord will come to page 166.
One second, let me note this.
Your lordship see the heading, subject, letter of displeasure, removal of the CEO MD of the bank.
Yes.
And page 167, clause 7, your lordship would see. What is the direction that has been issued, but they are violating that?
Yes. So directions also that the status quo should prevail.
And you withdraw that.
Where's the order number dated 28th November 23, referred to in para 7? Specifically the letter, where is it?
Where that page 165, no?
The withdraw order numbers also. Where is it?
Yes, page, my lord, will see 164.
That specific letter.
Oh, that's been written by me, my lord. 377.
No,
That is
no,
page
letter.
162. 162 is the letter. The chairman writes to me, my lord, a copy has been marked to the...
162?
Yes. Your lordship has seen the number 377 at the last.
Yes.
Now they are communicating it to me.
Okay.
My lord, see that serial number 1 copy has been marked to DGM RBI Department of Super.
You've impugned this?
Yes.
Yes. That's it.
And subsequent events are all consequential. The core of the issue is this only. And the other thing, the bylaws, the Act says from the date 5 years. They have passed one resolution in their bylaws that which says that from the date of taking over of the management. It cannot go against the Act.
We will not go there.
I understand.
Yes, what's the situation now?
The situation is valid. I'll just take a lot to the affidavit file also.
No, but if see, what is clear is that now that notification has been stayed, correct? And then the board resolution was there that he be removed as per the circular or 26.
But the board, there's a slight difference. What the board resolution says, my lord, that he was completing 3 years. I'll just take a lordship to the
November 23.
Yes.
Yes.
So board's only resolution is not to reappoint him, my lord, or not to continue with his service.
So you mean to say that this is independent of the circular?
My lord, we have referred to the circular, my lord, page 132. If I may take lordship once again, my lord.
132
of the writ petition.
NRC get following suggestions recommendation of board, yes.
Well, before that, my lord, page 127, this starts, my lord, in H21. Well, he is present in the meeting, he doesn't raise any objection in the meeting, my lord. Kindly see, my lord.
It doesn't matter about operation of the law, then he, or whatever circumstances, he's... Yes.
Well, that's one of the ground we have taken. This is 9th November 23, serial number 8, A.N. Muksor, CEO, he is present in the meeting, my lord.
Yes.
Now, my lord, page 132. If I will just read, my lord.
132.
132.
How's the bank functioning now then without any CEO?
We have appointed, my lord, or temporary.
Yes.
That the incumbent CEO was appointed by the board of directors in terms of guidelines contained in circular number so and so, dated December 31st, 2019, on the 20th November 2020, and the same was accorded by the RBI on 30th November 2020. Based from the date of appointment, his tenure of 3 years will be completed on 30th November 23 as per RBI circular number so and so. The NRC has expressed their unwillingness to continue with the service of the incumbent CEO and recommend that he shall not be reappointed after completion of his tenure. It's not a case of termination as such, my lord.
No, see, it's not a termination. The thing is that, see, you have based your entire, like, to truncate his service on the 25th 6, 2021 circular, correct? And so that what follows the corollary says that you have expressed your honest fine. Say once the tenure is over as per the circular, he's out. Fine, then he's fine. That is your decision. Above board, circular is in force. But then like, it's not in force.
When circular is under stay, my lord, what will the effect of that? That is
that what I have to address, yes.
Or in my affidavit, we have said, my lord, and I'll place a judgment also, my lord, on this. Para 38 on page 14 of my
affidavit. 4, 5, 6 and 7.
My lord. Para 38, page 14, my lord, the affidavit.
Para 38.
38. I'll hit 37 and 38 both, my lord. 37, my lord. And that the defendant further state the Honorable Supreme Court by the order dated so and so, passed in transfer petition number so and so, was pleased to transfer all similar matters.
You have 1 second.
Para 37.
1 second. You have 4, 5, 6 and 7, correct?
Yes, ma'am.
Para 37.
37.
Yes. Yes.
37. That the deponent further states that the Honorable Supreme Court, by the order dated 14/10/22, passed in transfer petition number so and so, was pleased to transfer all similar matters challenging the validity of the Banking Regulation Amendment Act so and so, dated 25/6/21, to the High Court of Madras, This honorable court
That's
by
why that's the only concern this court is having.
My lord.
To say very frankly, that's the only concern that whether we will not tread on the toes of any other matter where Supreme Court directed the matter. That's the only thing. So whether taking it will amount to diluting the.
My lord, that is one ground we have taken. My lord, the next ground, page 38, para 38, my lord, that the deponent further states that the interim order passed by this honorable court by the order dated 17/4/24, passed in WPC number 109/2024, that has been transferred to Madras High Court, my lord, is only an order staying the operation of the circular dated 25/6/21 as directed by this honorable court, and only means that the circular dated 25/6/21 will not have effect to the extent as directed by the honorable court, and does not mean that the said circular has been wiped out from the existence. Only quashing of the circular dated 25/6/21 would result in restoration of the position as it stood prior to 25/6/21. As such, still the matter is pending, and only the order of stage operating, the relief claimed by the petitioner is not taken.
No, see, we are borderable consequential. We consequentially, even your 38 environment, it's not really there. The thing is
Malad,
that
38
consequential sense that once it's been stayed, what happens?
Malad, 38.
It means you are talking about restoring him because after the stay order was passed, he's already out of service, correct?
Malad, 38 it becomes relevant.
When the order was stayed, this circular, was he still?
He was not.
His term was still.
No, not married. Because the order was passed.
Blood, I have never been terminated because that requires a RBI termination approval. Blood, only they have forceful.
That's only consequential. Consequently, that means he's not been terminated.
Lots
formally. And so the thing that he'd be
30/11/23 is where when he completes 3 years, my lord.
As per the circular has been stayed.
My lord.
But then even for that, you required approved RBI.
Now, secondly, my lord, the stay order passed by this honorable court was on 17th April 24, my lord. So there is a vacuum of 5 months, my lord. Somebody else has been appointed in his place. So, my lord, stay would result in consequential continuance, my lord, had he approached before 30th/11/23, my lord.
No, but then it's consequential also. The other
and that is
that
that
the other way also.
And
in the
that is
sense
the second aspect also.
That you ask status quo directly be maintained by Reserve Bank. The letter informing Reserve Bank about that he'd been removed from service that like don't give effect to that. Status quo maintained.
But my lord, that is
where
on.
Where does it leave the?
But my lord, that letter.
The only concern is that since the main matter is
pending before the Madras High Court, my lord.
Otherwise,
if your lordship permit, even for ad hoc appointment, that eligibility criteria is required, and for that also approval.
We have no doubt about that. We understand that perfectly. Only thing is that
the person qualified, my lord, and who's been serving, my lord, he's been deprived of, and only on a, my lord.
Yes, Mr. Botakur, correct? Yes. Yes. What the RBI has not approved his termination.
No.
That's it.
Letter at the Alex at 30.
Yes, we've seen that.
But in fact, he's out, my lord, for past 2 years as you stand today, my lord. So whether lordship will upset the entire thing that is prevailing at this stage, my lord, for last 2 years, my lord.
We're not concerned about that. We're concerned about whether any
and that also an
application that emanates from this circular, whether it can be entertained at all, because it's an ancillary issue which has to be addressed by where the circular is under challenge only.
That is our first.
What will be the effect of circulars that the circular has been stayed, but also civil situated? There must be other CEOs also.
Yes, Lord, they are functioning, Lord. In other cases, they are functioning.
Where is the evidence?
Lord, my case.
Functioning, you get an order from Madras High Court.
No, Lord. What I say is.
Show the other orders where would have been removed, have been restored.
Lord, what I am submitting before your lordship is this. Lord, the RBI, who is the author of that circular, that said I am not implementing it because that is a stay.
So, Mr. Botakur,
that has already been stayed.
He continues as CEO.
Yes.
What is your stand? Can you make a categorical stand that he should continue CEO?
That the order of status quo and otherwise, the lordship will find it answer 30th page 16 May.
Yes.
In fact, not on the basis of that circular of 25/16. Otherwise, I am reading it.
Yes.
In this regard, your attention is related to
page number.
Page 166.
Yes.
It's a letter from RBI to the chairman of the corporation. Urban 166 and it's a classic.
Reply, yes.
In fact, in
Para 7.
Yes, in fact, in our affidavit of citizen.
Yes.
We are in receipt of the letter of the Sunshine dated November 28, 23. In this regard, your attention is invited to minute of the SAF quarterly meeting data August 29, 23, wherein the CEO has highlighted certain issue against the functioning of the BOD, especially against the chairman and the vice chairman of the board. It appears that subsequent to the above-mentioned meeting of BOD has decided to remove the CEO forcefully without giving any prior notice conclusion of his tenure. Further, two professional directors of the board bank has resigned from the board, citing the reason of being sidelined from the board. In this regard, a letter dated November 1, 2022 was sent to the chairman of the board advising him to submit clarification regarding the resignation. However, we are yet to receive any response in this matter. The BOD has failed to attend the meeting scheduled with RBI through our email dated November 2023. The action taken report on the quarterly SAF meeting dated August 29, 23 has still not been submitted by the bank deposit despite our various reminders. It clearly indicates the serious issues in the functioning of the board. The method was, this is important. The matter has already been taken up with Mr. Swanshaw, the Chief Secretary of Government of Meghalaya, on November 28, 23, wherein the Chief Secretary had advised the Finance Department, Government of Meghalaya to urgent look into the matter. Hence, until the matter is properly investigated, you are strictly advised to refrain from doing any activity which raises serious concern regarding the integrity of the board and managing of the bank in professional terms. Accordingly, you are advised to withdraw the order of so-and-so, that is the impugn order, regarding removal of the CEO immediately and maintain the status quo regarding position of the CEO and other officials of the bank. BOD subcommittee beyond until the matter is examined thoroughly by the concerned authorities.
So that means this order is independent of that circular. Yes.
But
Then we'll pass order.
along with this, your lordship will also read page 190.
My lord, you will kindly consider that the deputy CEO, my lord, he is discharging the function as CEO since.
Doesn't matter. So we are just going by records. Not adding any extra.
Page 190, my lord. It is Department of Supervision, discussion of Joy Corporate. 190, clause 3. The chairman stated that they have removed the CEO after completion of his tenure of 3 years as per the instruction in RBI circular so-and-so. In this connection, DGM RBI stated that CEO has been removed without any due notice and tenure of the CEO was not mentioned in his appointment letter. But the RBI says CEO has been, as per the circular, the tenure so-and-so. So in the case the bank decides to terminate service before the expiry, it shall be seek prior approval by submitting detailed reasons. If CEO has been removed on account of completion at least 4 months prior to completion of the tenure, the bank should have initiated action for appointment and use. However, it is imperative to mention that the circular EBD is on holds as per Honorable Court order.
So it's again coming back to circular.
That's why the RBI says it will continue that.
If it comes back to circular matter, then what is the effect, madam?
But they want to give effect to a circular which has been stayed, and they don't want to give effect to the direction which they are bound.
Well, I'll only place this one judgment, my lord.
Yes.
It's 92.3. I'm just reading para 10, my lord. I'll read somewhere. I think I've highlighted also.
It's highlighted. Well, considering.
My lord. Well, considering the effect of an interim order staying the operation of the order under challenge, a distinction has to be made between quashing of an order and stay of operation of an order. Quashing of an order results in restoration of the position as it stood on the date of the passing of the order which has been quashed. The stay of operation of an order does not, however, lead to such a result. It only means that the order which has been stayed would not be operative from the date of passing of the stay order and does not mean that the said order has been wiped out of existence.
Yes. Chamundi.
So, my lord, the RBI resolution also again refers to stay order passed on this by the Honorable Court. My lord.
I don't think so, Dr. Muzika.
Page 190, my friend was
referring. Yes, fine, but then that order whereby they've been this banks been given specific directions, that is totally on a different premise.
Malad will also see I have also annexed the series of orders passed by various high courts, Malad, at 214 onwards, Malad. There also, Malad, stay orders have been granted and not to take any matter adverse action against such petitioners.
Malad, page 190 is subsequent to that, Malad.
Yes.
They have clarified in that PT.
Page
190 is subsequent to that, Malad. To the earlier letter. In the earlier letter, RBI did not mention anything about the circular stay of the circular, my lord. But the subsequent this letter on page 190 again talks about the stay order passed by the court, my lord.
Well, transfer PT
Then the
orders.
question again comes whether what is the effect of stay order, my lord? Can status quo ante be?
No, my lord. It's not a question of status quo ante, my lord.
That's one thing, my lord. And the second aspect, my lord. When this main matter is pending before the Madras High Court, your lordship will intervene.
That's the only concern, but then this letter clarifies it. Just come back 5 minutes. Yes.
I want to point out, page 146 is a letter by the petitioner to the Deputy General Manager, Department of Supervision. 146.
Yes.
On one hand, he is
well, have you filed an affidavit?
Yes,
146.
Yes. Annexure 24. 146.
You don't give a copy.
One hand challenging the
notification of 25/6/2021. That in this letter, the lordship would find it page 148.
Yes.
He is also supporting the guidelines from under the same notification.
Who, the petitioner?
Yes, ma'am.
Doesn't matter.
Yes, correct.
That's what it is.
It seems that RBI has filed some affidavit. They have not given us a copy.
They have filed an affidavit.
It's
all matter of record.
Tomorrow I'll just go through.
Give me a copy.
They have not given us a copy. I don't have in my file.
Copy to all the respondents.
At this last stage,
tomorrow, my lord, I'll just go through the affidavit and I try to seek some instructions.
But they have some. Malad will also see the orders passed by the high courts. Page 214 onwards, Malad.
I have given the copy.
Copy is there.
You received a copy earlier on?
Yes, ma'am.
Is there? I'm sorry.
At page 214, Malad, there is a stay order.
Gangarpur wala.
Then Mumbai High Court, Malad. Status quo service at page 217 by Punjab and Haryana High Court, Malad. And then Karnataka High Court also passes an order.
Page
214 onwards. At page 222, Malad, Jaipur, Rajasthan. In the meanwhile, no actions against the petitioner pursuant to Malad, if the RBI had approved my termination, it would have been a different case, Malad.
Yes. Give file. I'll come back. Details.
But I have 2 or 3 small submissions. My Lordship kindly comes to page 74, my Lord. These are the new 21 guidelines, my Lord, where the tenure has been cut to 3 years.
Yes.
Page 74.
Something matter. 74. Yeah.
74, my Lord. Now this is a part of June 25th June 21 rules, my Lord, which are under challenge. Now clause 5.4, Lord, so kindly see, my Lord.
Yes.
Termination of MD WTD by UCB. In case a UCB decides to terminate the service of MD WTD before the expiry of tenure, it shall seek prior approval of the Reserve Bank by submitting detailed reasons thereof along with the relevant documents and board resolution to that effect. So this is applicable, my Lord, prior approval RBI in case of premature termination before the expiry of tenure, my Lord. Our case is, my Lord, here he has completed 3 years tenure, my Lord, and that's why this prior approval of RBI is not required. That's one aspect, my Lord. Second aspect, my Lord, Lordship kindly sees the prayer, my Lord, because they are trying to take the writ petition to a different angle, my Lord. But your Lordship kindly sees the prayer, my Lord, at page 41. The prayer number 1, my Lord.
Yes.
Impugned to set aside, my Lord, the impugned recommendation of NRC of terminating the service of the petitioner and rejection of his reappointment as CEO on the basis of circular dated 25/6/21, my Lord. Impugned decision of the Board of Directors of the Respondent Bank of approving the recommendation of the NRC in its meeting held on 9/11/23 for terminating service of the petitioner. The impugned letter of termination, so and so, so and so. So, my Lord, all the prayers are founded on 25/6/21 circular, my Lord.
Yes.
So now they cannot try to distinguish a separate cause of action because RBI has asked for maintenance status quo, my Lord. Because their writ petition is framed on 25/6/21, my Lord. The second aspect. Third aspect, my Lord, I was going through the affidavit filed by Reserve Bank, my Lord. Well, the Reserve Bank says, my Lord, at para 9 and 10.
Yep.
At para 9 it says, the affidavit says, my Lord, and submission is something different, my Lord.
Para 9?
Yes, my Lord. Page 8.
Yeah.
It says that it is respectfully submitted. While on one hand the petitioner is disputing the enforceability of the RBI circular dated so and so, on the other hand the petitioner is seeking to place reliance on the requirements contained therein to support the challenge to termination, which this honourable court may not permit. That's one, my Lord. The next para, my Lord, that for the foregoing reasons an argument to be presented at the time it is simply submitted that the writ petition may be dismissed as against the respondents.
As against that respondent only.
It doesn't say so.
Not against the respondent number.
It says the respondents, my Lord. So,
One
my Lord, to sum up my case, my Lord, that writ petition is framed on the basis of 25/6/21, my Lord.
Yes.
This writ petition is not framed simply on the basis of RBI letters, my Lord, subsequently, which they are trying to rely now. And because the main subject matter is pending before the Madras High Court, my Lord. Now, there are two arguments stem from that, my Lord. The first is that since the main matter is pending before the Madras High Court, consequential relief cannot be granted by this honourable court, my Lord. And thirdly, my Lord, only because of by stay order of this honourable court as a place judgment, this is only keeping in abeyance of the 21 rules circular has not been wiped out of existence, my Lord. So at this stage, my Lord, and another aspect, my Lord, the earlier orders my friend is referring to from page 214 onwards, my Lord, those are the orders passed in 2021, my Lord, immediately after the circular came into being, my Lord. All the orders of 21 and early 22, my Lord. So that means that they were in service.
People were at the time that the fag end of that tenure of 3 years. That's why they had come. That's all.
Because they were in it is evident that they were in service when the petitioner approached this honorable court, my lord, and that is why they were allowed to continue as a consequential measure, my lord. Same interim order was passed by this honorable court, my lord, but this honorable court did not grant such consequential relief to them at that point of time, my lord. So in my humble submission, after 2 years, my lord, to restore some kind of status quo ante at this stage, that too only on the basis of stay order, my lord. Had it been set aside and quashed by Madras High Court, my lord, I would not submit that.
Yes. Yes.
That's my case, my lord.
Of the bank. Have you taken over as CEO?
He is discharging, my lord.
Just handling the affairs as deputy CEO.
But no one's appointed.
No. Your Lordship has stayed, my Lord. There is an interim order.
Appointment has been stayed.
Interim order operating in my favor. My Lord, just in reply 2 lines, my Lord, will kindly come to page 45.
Of your petition?
Yes.
Will never be ending then.
Yes, just one thing, Lord, how it's been interpreted. Right, this is the circular dated 31st December 2019, pursuant to which I was appointed. And now your Lordship kindly come to page 48, clause 12. Lord, we have not challenged this. This is still holding. My friend says I am taking advantage of that. Lord, I am not challenging and accepting that.
I am not simply, RBI is saying that. I have not said anything.
That is the wrong submission, no, Lord. Clause 12. RBI shall have powers to remove any member of BOM and or the CEO if the person is found to be not meeting the criteria prescribed by RBI or acting in a manner detrimental to the interest of the bank or its deposit. The BOD shall seek concurrence from RBI before removing any member of the accepting the resignation, so and so, so and so. So, my Lord, pursuant to this circulars, my Lord, that prior approval is required. This is still holding the field.
Yes. Yes. Anything else?
And your Lordships, while Lord, in issuing notice in this case, was pleased to stay the further appointment. And Lord, also issued notice on the further interim prayer, Lord, and eventually it was decided that your Lordship would decide the entire matter.
When was this matter filed?
March 24.
April 24.
April 24.
Mr. Shula, anything to say? No.
Lordship, so far as case is concerned, Lordship, this is the internal matter between the bank, Lordship. So the state would have no major role, Your Lordship. The only concern, Your Lordship, is that the order, he came, Your Lordship, say after a period of a year, Your Lordship. And Your Lordship, by the interim order, Your Lordship, has passed that order, order of status quo, Your Lordship. As of now, Your Lordship, the bank it has entrusted the job, Your Lordship, to the deputy CEO. So, the Your Lordship, since there is a lot of time, Your Lordship, my humble and respectful submission, Your Lordship, if he is brought by, Your Lordship, there may be unsettling of the affairs in the bank, Your Lordship. Your Lordship will kindly take note of that also, but this is my humble and respectful submission. That's all.
He is coming in a hostile way, my lord. We are managing public funds well. We are managing public funds, and if he comes in a hostile way, my lord, that also is a CEO.
There are guidelines, my Lord, which says, my Lord, if they can proceed departmentally against me, my Lord, in terms of the rules.
The board can proceed against you if you're behaving in a matter which is...
Yes, my Lord, they have a power.
Which is a matter which is like destructive to the function of the bank. It's like any other company.
Yes, my Lord.
But because the correspondence which I annexed with them shows that there's a lot of hostility between the CEO and the Board of Governors.
But Dr. Mojika, you see, the thing is that by operation of the law itself, what's happening, court is bound by that. We cannot add more to that or subtract it. Only if it comes to an arbitrary action in such a case, that maybe he's guilty of such egregious acts, which makes him unsuitable for other considerations.
On that, my lord, it only appears that RBI letters, only those are the factors in support. Now, RBI has not taken any action after that, my lord, after writing that letter for past 3 years. We are totally, we are totally under RBI, my lord. If RBI writes us a letter tomorrow, my lord, that you appoint him, we are bound to appoint him.
Yes, sir. See.
After that matter is sub judice, my lord.
See para 8. See para 7 of the letter 166.
Well, immediately after
otherwise,
that,
we
matter
draw
sub
order
judice.
number so
Yes.
regarding who CM immediately maintain self-scoring positions also.
My lord.
All directors shall be personally accountable for any mismanagement in the bank. So that's rider also given.
But this is of November 23, my lord, this letter.
Why all issue arose? Because my lord, I lodged a complaint because there was irregular appointment was made by the member of the board of directors. My lord, that are also on record. I have not, my lord, submitted that. There have been reasons.
Yes, take down.
March 24.
The petitioner, who is stated to have been serving as the Chief Executive Officer of the Joy Cooperative Urban Bank Limited, is before this court by way of the instant writ petition. Praying for quashing and setting aside his removal on the basis of a circular dated 25/6/21 and has also impugned the decision of the board of directors of the respondent bank. It is meeting held on 9/11/2023. As also impugned letter of termination of service dated 22/11/2023. Before adverting to the arguments advanced by the respective counsels for the parties, it is relevant to note herein that a circular dated 25/6/2021, which had been issued by the Reserve Bank of India, respondents.
892.
Where's the circular?
Case 68 and it's a second.
Oh, no. Wherein? Where are the provisions for 3 years?
Clause 4, my lord.
Wherein?
At page 71.
71. Clause 4.
At clause 4 thereof, the tenure of MD stroke CEO had been, where are the 3 years? Yes, sir, had been prescribed to be not for a period of more than 5 years at a time, subject to a minimum period of 3 years at the time of first appointment. Stop. It appears that the board of directors, apart from other considerations, had based its resolution for removal of the petitioner from the office of CEO. Stop. The same is reflected in the minutes of the BOD meeting dated 9 November 2023, wherein at para 7 anta small a, it has been noted that the writ petitioner, having been appointed on 20/11/2020, with the application of the RBI circular dated 25/6/2021, his services were to conclude on 30/11/2023. Next paragraph. This circular became the subject matter issue this circular then came to be challenged across many high courts in the respective jurisdictions, and it appears that the same, the Madras High Court was the first one to state.
Yes.
And the same having been, and the same was stayed by the Madras High Court. Madras High Court, whereafter by an order of the Supreme Court dated 14/10/2022, passed in a batch of transfer petitions. Directions were issued that all similar matters challenging the validity of the circular dated 25/6/2021 would be transferred to the High Court of Madras. Stop. With regard to the incident, with regard to the petitioner, with regard to the incident petitioner, with regard to the petition question, with regard to the with regard to the respondent bank, with regard to the petitioner, as the OPC number 109 of 2024 had been challenged by him. With regard to petitioner, wherein he had placed the same challenge to the circular dated 25/6/2021, this court by order dated 17/04/2024, in compliance with the orders of the Supreme Court, then transferred the said petition to the Madras High Court, and though in stay orders operating, the same is in the stage of hearing, and no final orders have been passed. By the subsequent writ petition, as noted above, from the facts as placed, on the facts as noted earlier, the writ petitioner was removed basically in consideration of the directives of the circular dated 25/6/21, which has since been stayed. This court, therefore, at this juncture, is only to examine as whether the writ petitioner will be eligible to continue in office by virtue of the stay order, by virtue of the stay of the circular dated 25/6/21, or whether he may be allowed to continue in office on other considerations and facts which are peculiar to the instant case. Now, next paragraph. Ms. Adube, learned counsel for the petitioner, has submitted that what is crucial to the issue is the manner of appointment and removal. That's what you say, correct? In instant case, he submits the writ petitioner was appointed when the earlier circular dated 31/12/2019 held the field. Where's the circular? In this connection,
page 45.
In this connection, learned counsel has drawn the attention of this court to
clause 12, my lord, and page 45 circular.
Has drawn attention of this court to, where is that? Clause 12.
Yes, page 48.
Clause 12, yes, of the said circular, and submits that the board of directors of a bank shall seek concurrence from the RBI before removing any member of the or accepting resignation tendered by any member of the board. So, he contends that in view of the fact that the circular dated 25/6/21 has since been stayed, the earliest circular of 2019, which mandates the approval for removal, will have to be complied with. Learned counsel has then also argued that though the impugned decisions had been taken for his removal in the board meetings dated 9/11/23 and
21/11
and
21/11
20
1/11
21 yes 21/11/23 the same will not be effective unless it was concurred to and approved by the Reserve Bank of India. Learned Counsel further submits that the Reserve Bank of India, by its communication dated 29/11/23, had instructed the bank, had directed the respondent bank to withdraw an order dated 28/11/2023 regarding the removed petitioner, and that status quo with regard to position of CEO be maintained. This he submits by not allowing the petitioner to discharge his duties as CEO has been flouted. Next paragraph. On another limb of submission, that counsel has submitted that though the matter concerning the circular dated 25/6/21 is seized by the Madras High Court, this writ petition is maintainable before this court, as the facts and circumstances surrounding the same show that the case of the petitioner does not entirely hinge on the circular, but is but the services of the circular, but that the services of the petitioner but the removal petitioner, but the question of removal petitioner is severable from the aspect of the circular dated 25/6/2021. As such, he submits the procedure having provided one of the relevant it's not statute, these are relevant regulations or circulars in operation and terms of appointment having mandated approval of the Reserve Bank of India. The non-receipt of approval would make the order of removal by the board of directors ineffective, and as such, for practical purposes, the petitioner is to be considered to be still in service. He therefore prays that directions be issued that he be allowed to continue as the CEO of the respondent bank. No authority is. Anyway, next, Dr. Mozika, who, yes, Dr. Mozika Leonard, counsel for the respondents number.
4 to 7.
4 to 7.
4 to 7 were the main answering respondents. In his submissions, has pointed out that the entire writ petition and the relief claim of the writ petitioner is founded on the operation of the circular dated 25/6/21, correct? That's 21. And that if any consequential relief is being sought, the same will have to be before the forum that is seized with the matter. Stop. Learned Senior Counsel has contended that the prayer of the writ petitioner, these the relief came by writ petitioner today, going beyond the prayer made writ petition, no relief will be permissible. Stop. What do you want to show from the materials? Anything? No.
But my main submission is that it is only a stay, my lord. It is not.
No, that will come. That's the other submission I'll record. But from the materials, anything you want to show?
He participated in the meeting, my lord.
Yes.
He was present in the meeting.
That in the meeting dated 9/11/2023.
Did not raise any objection there.
The writ petitioner himself, in the meeting in the board of directors meeting held on 9/11/2023, wherein the removal of the CEO had been discussed and recommendations made. The writ petitioner was himself present and also appended signature and also appended signature to the said resolution, which he submits as stops him from questioning the decision by the incident petition. Next paragraph. The Senior Counsel has then, on the question as to whether stay of circular would automatically revive the status of the writ petitioner in the office of CEO, has submitted that the terms of the writ petitioner had been considered to be had been considered to be over on 20th on November 2023, and that the incident petition was filed only on April 2024, and it is not a case where the writ petitioner had approached this court had sought legal remedy when his tenure was still subsisting. Stop. He further submits that the suspension of stay orders operating with regard to the circular dated 25/6/21 cannot mean to have the effect of reinstating the writ petitioner into the office of CEO. In this regard, Oh, you've given me a paper. In this regard, the Learned Senior Counsel has placed reliance on. No, I got it here.
92.3.
Has
SSC 1.
placed, yes, sorry. Has placed reliance on a judgment of the Supreme Court in the case of so and so, reported in 92.3 SSC 1, where he submits that where he submits at para 10 thereof, the Supreme Court has held that there is a distinction between quashing of an order and stay of operation of order, and that is only the quashment of an order which means it's only quashment order which will result in restoration of a position as it stood before its quashing. So he concludes submissions. Anything else he had submitted?
Only one more. They have referred to the 19 rules, page 48. Which talks about BOD shall seek concurrence from RBI before removing any member of BOM.
Yeah.
So CEO, in my humble submission, will not be protected by this.
He was covered by that. Yes, he in concluding submissions, the Learned Senior Counsel also submitted that the circular of 2019 would have limited application to the case writ petitioner, as the same speaks only of removal of a board member
BOM.
and not of a CEO. So, then submission of Mr. Shulai, nothing. Mr. Shulai is
1, 2, and 3, Your Lordship.
yes, Mr. Andy Shulai, on behalf of 1, 2, and 3, has only submitted that due to the time lapse that has occurred, the restoration of the writ petitioner into office might result in dislocation of the functioning of the bank, which may have a detrimental effect as it concerns matters of public finance and revenue. Stop. Then Mr. P. Wathakur appearing for the respondent. That's respondent number
8, 9.
8, 9, 10.
And P. Hazarika.
Oh, sorry, P. Hazarika. Appearing for the respondent 7, 8, and 9. Bracket RBI has submitted that though it's a fact, has submitted that the RBI by user letter 166, correct? By its letter dated 29/11/2023, in reply to a letter dated, in reply to the respondent bank's communication, a letter dated 28/11/2023, wherein an intimation was given with regard to the copy is given to RBI here.
Yes, Your Lordship. First page.
So that
First
will be
note.
expressed displeasure to this one only.
166. Huh?
Where intimation was given to the petitioner about the termination, where a copy marked to the RBI had expressed his displeasure and had advised or had directed the respondent bank to withdraw the order number so and so, whereby the writ petitioner had been removed. He further submits that. What's your further submission, Mrs. Zarika?
There is a serious governance issue. That's why we're
Order of status quo. Submits
not
that.
for staying up
Yes,
with
submits that though the issue regarding the circular is important, the said letter had been issued in consideration of the fact that there was serious governance issue within the respondent bank itself, as has been expressed in the said letter. Then Mr. 111, Mr. Kharkrang, that Constable, he submits that he, since the termination from service of the writ petitioner, he's been serving as the deputy CEO, and further has supported the submissions made by Learned Senior Counsel on behalf of the respondent bank. This court, having heard all other counsels for the respective parties, and also having examined the materials on record, firstly, Court finds that the issue in question is twofold. First is the matter of the circular dated 25/6/2021, which has since been stayed and is pending hearing before the Madras High Court by virtue of orders of the Supreme Court. And secondly is the circumstances that surround the termination of the writ petitioner, which are peculiar to this case itself. Stop. The writ petitioner, it is seen, was appointed on 18/11/2020 by the bank, and this appointment received post facto approval on 29/1/2021 from the Reserve Bank of India. Stop. The petitioner, in his service as CEO, the ways that bylaws
Page 57, Lord, and page 61.
Page
61, Your Lordship would see.
Therefore, on being appointed as such,
and
will be
it
bound
says,
by the bylaws. and as reflected in the same, the post of CEO has been placed at grade, what's grade Z?
Grade Z, my lord.
At grade Z in the cadre, as inasmuch as per the bylaws, all employees were to be graded from. Having been appointed as such, where's that thing where
Lord, page 64, rule 63, my lord, bylaws 63.
yes, that we've seen. Now, where's that
Z, CEO, my lord, at page 62.
yes, 62, we noted that 62 CEO, convert bylaws, and that part where approval of the removal of, and appointment and
Well, that is in the appointment letter, my lord.
approval and termination to come from the RBI. Where's that? Approval, appointment and termination of work.
At page 54, my lord. The first appointment itself, appointment of CNR was subject to approval from the RBI.
Yes.
And there also, my lord, in that clause, you will be bound by the bylaws of the society and staff rules and general regulations of that.
The conditions of service of the writ petitioner, therefore, was that he was bound by the bylaws of the bank, as also the general regulations of the RBI, wherein appointment and termination was subject to approval. Stop. The respondent bank, it is noted, as earlier observed, in its BOD meeting dated 9/11/2023, had recommended the termination of service of the writ petitioner based on the circular dated 25/6/2021, which has since been stayed. Since been stayed. I don't think I'll refer to the other board resolutions, yes. BOD. And the same was echoed in another communication dated 21 November 2023 to the Reserve Bank, wherein concurrence was sought for the said resolution. Stop. Next paragraph. The aspect of the stay of the circular dated 25/6/21. In the concert view of the court, if the termination of the petitioner had been concurred to or approved when the said circular was subsisting, no relief would be admissible to the petitioner at this stage. Stop. Another aspect which has been vehemently argued by the respondent bank, that is, any consequential relief prayed for by the petitioner will have to be necessarily be before the court where the matter concerning the circular is being adjudicated, will not, however, debar the court from examining the other factors and attendant facts and other attendant facts and factors surrounding the matter. Stop. The most important is that the services of the writ petitioner, notwithstanding the resolutions and the non-discharge of his duties, have till date not been formally approved or concurred to by the competent authority, which is the RBI. Stop. This is evidence from the communication dated 29/11/2023, which, for the sake of convenience, is reproduced in its entirety herein below. A detailed perusal of the above quoted letter does not in any manner refer to the operation of the circular dated 25/6/21, but in fact is the communication of displeasure with regard to the removal of the writ petitioner without any reference whatsoever to the circular. Stop. No doubt the pendency of the challenge to the circular is important to the functioning of the bank. Or rather, all concerned banks across India. With regard to the tenure of MDs or CEOs. In the instant case, what can be clearly discerned by this court is the fact that the termination of the writ petitioner has never been final. and that for all practical purposes, in the backdrop of the facts, in the backdrop of the materials and the letter dated 29/11/2023 would be deemed to be in continuance. Stop. Accordingly, in the backdrop of these facts, circumstances, the contention of the respondent bank that the petitioner, that the relief claim by the petitioner would be available only before the court where the question of the circular is pending is not accepted. Though the other contention that the prayer petition is limited or directed in the circular is of no consequence presently, inasmuch as per the situation and the facts as they stand, the petitioner is deemed to be still in service until other orders follow. Stop. Though, next paragraph, before parting with the records, though some concern has been raised by the state respondents as well as the respondent bank that the reinstatement of the petitioner to post of CEO would have adverse effects and repercussions on the functioning of the bank, this court will not pass any observations the same, as inbuilt mechanisms exist in the regulation of the bank itself to deal with such situations. So in the result, writ petition is allowed. In the result, the respondents are directed to. Can we direct you to take a decision, or we don't direct you reinstatement?
My lord, only page 167, the RBI letter, what it says, my lord. I'll just read the last sentence, my lord. Accordingly, you are advised to withdraw your letter number so and so regarding removal of the CEO immediately. Maintain status quo regarding the position of CEO until the matter is examined thoroughly by the concerned authorities.
Exactly. That was the internal mechanism.
So they let RBI take a decision, my lord.
Yes.
RBI communicate a decision, we will reinstate him.
No?
And secondly, my lord, the reinstatement has to be subject to the pendency of the Madras High Court, my lord.
To take a considered decision in the matter, keeping in mind the fact that as on today, the petitioner has never been terminated formally. Stop. The petition stands allowed to extend indicated above.
26.
I'll embellish it, but
May it please your lordships. This is a case, your lordships. My lord, the contentious issue here is, my lord, the petitioner, my lord, who is working as a lecturer in Shillong Polytechnic, my lord, has been granted, my lord, what is called, my lord, AICTE pay scale. All India Council for Technical Education pay, same as UGC, my lord. UGC, what happens, my lord, their pay scales are extended to central universities and colleges. And state government also given an option, my lord. They can extend it to the state colleges also, my lord, provided they have the norms.
we can finish in half an hour.
I can try, my lord. I can try. The short issue, here is the issue
So
is, my lord,
prayer.
my prayer is this, they have granted me with effect from 2011 the AICT pay scale. Now what happened, your lordships? Now the UGC AICT norms is first class, PG1 of the qualification, first class, my lord, that is 60%. Now, my lord, this was withdrawn in 24 on the ground, my lord, that I do not fulfill the ROMs, citing the reason, my lord, that I have not
given and withdrawn.
Yes, my lord.
Was it given and then it was taken back?
Taken back. That is, my lord. But the reason is, my lord, that I do not have the first class, but they have totally ignored the fact, my lord, I am a tribal candidate, my lord, employee, and I have obtained 55.25%. And as per the AACT regulation, my lord, they have made it clear, my lord, so far SC, ST are concerned, my lord.
Paying for ICT, you are paying?
I'm paying also.
Okay. And Mr. Karmapla?
The AG, the respondent, 9.
Now, my lord, regulation very categorically says, so far, my lord, reserve categories are concerned, they are entitled for the relaxation to the extent 5%. My lord, if 5% is added, my lord, I qualify.
Take it up at 215.
No, I leave it to your lordship, subject to the convenience of my lord.
Then tomorrow, your lordship.
Subject to the convenience, my lord. Whatever lordship thinks convenient, my lord.
No, I see this court's at the mercy of the lawyers. If you want to take 215, we'll hear it.
Then can we have the matter tomorrow?
Whenever your lordship wants, my lord, I am available for this.
115 now. Today?
Tomorrow, your lordship, then. Tomorrow, your lordship.
Short interesting issue, my lord.
We'll not have it tomorrow. If we adjourn it, will be after 1 week. Otherwise, you come at 2:15 and argue it.
My lord, so far I am concerned, my lord, anytime your lordship.
Okay, after 1 week then.
After
otherwise, otherwise we'll have it. I'll have to get other orders also. So otherwise,
apply, your lordship.
2:15. Yesterday also we had a matter 2:15 till no issue.